All due respect, like I said, I don't have anything personal against this court. I'm not a corporation, right? I'm a natural person. Where is the body of the crime, Judge? You went to law school, you're a practitioner.
I don't know because I haven't heard testimony.
This one is on a whole different level because a so-called sovereign citizen storms into court with the confidence of someone who thinks the rulebook simply does not apply to him, and from the first second he opens his mouth, you can tell he is not here to listen, he is here to argue. He truly believed he could drive without a license, like traffic laws were just friendly suggestions, and somehow he is shocked that the system did not bend to his personal theory of reality. He keeps talking over everyone, refusing to calm down, acting like volume equals victory. But what really caught me off guard was the judge, because instead of matching his chaos, she handled it in a way that completely flipped the power dynamic, and I genuinely did not expect that reaction. I will not ruin the moment for you, but let us just say the energy shifts fast, and what starts as loud defiance slowly turns into a reality check. You have to see to believe, so watch closely and tell me what you think, because this might be one of the wildest courtroom meltdowns yet.
All due respect, like I said, I don't have anything personal against this court or anything. I just request that this court adhere to the supremacy clause of the U.S. Constitution and hold that these state statutes in which they have me charged with are constitutional based on the U.S. Supreme Court. And what is the case? The Shaney versus Winnebago Department of Social Services, there was a young child whom the mother alleges that the father was beating the child, and the child died. The mother sued all the way to the U.S. Supreme Court, and the U.S. Supreme Court held that no matter how bad or gruesome that this case was, when it concerned the case, that the states have no duty to protect citizens from other citizens. Anything that compels performance, there has to be a contract. And again, I reserve my rights under UCC 1-308 and the common law UCC 1-103.6. And it's clear, Your Honor. And I ask that this court, do their sworn fulfill their sworn oath under the Michigan rules, the Michigan Judicial Code of Conduct. The court is not to be swayed by public opinion or what the people may think or whatever it may be. Like the great honorable Judge Dalton A. Robeson. So every government is entitled to a Republican form of government, not a corporate. I'm not a corporation, right? I'm a natural person. The case law clearly breaks everything down, which everyone is in default. I just ask that this court dismiss this case at this juncture. If the court does not, I demand under the supremacy clause, the subpoena power of this court, to have Ken Worthy brought in so we can have an evidentiary hearing. Because how can a criminal prosecute or allege that I'm a criminal when they're committing all the crimes, Judge? Since I've been home, I've been making reports of police and other things, violations of law against me at the precinct. And no one listens to me. They just ignore me. But when people call and say, well, hey, Mr. McCrary did this, Mr. McCrary did that, they come, then it's found out nothing happened.
Under our state constitution, this court has jurisdiction. Furthermore, as far as discovery goes, I personally sent Mr. McCrary twice, and I have the emails, copies of the emails to show that that's necessary.
What are the dates?
Dates are not on here. May 24th, which was last week, and May 5th.
Look at him over there shaking his head like he did not just wipe those emails off his inbox, like we all did not hear the prosecutor say they were sent days ago. This man is so locked into his own storyline that he might actually believe it himself, and I cannot even lie, the commitment is almost impressive because the confidence never cracks, even when the facts are staring him dead in the face. It is so obvious he is bluffing, but he delivers it with the energy of someone defending a PhD thesis. And that is what makes it hilarious and painful at the same time. The level of delusion is off the charts, yet you have to admit these sovereign citizen types will stand 10 toes down on an argument, no matter how thoroughly it gets dismantled. The judge can explain it, the prosecutor can prove it, the paperwork can confirm it, and they still will not fold. It is like they think if they deny reality hard enough, the law will just get confused and walk away. Spoiler alert, It never does, so now I have to ask, are we respecting the stubborn dedication, or are we witnessing elite-level self-sabotage, because this right here is a spectacle?
No, I'll give you, it's gonna take a couple seconds. One of those emails, the E is missing in there.
That's not my fault. They violate your order. Yes, ma'am.
Okay. So you should have received one of them,
Nothing.
and neither one of them came back as bad email.
Okay. All right, so Mr. McCurry, I don't know why you're not receiving discovery, you did not receive it?
He didn't send, can we subpoena Google and,
No,
litigate this and
This
show that
is
he
not,
hasn't
this
sent
is not a
anything?
trial, this is not evidentiary hearing.
Well, can I say one more thing?
After we get done today, we confirm your email address, you can send a test email to make sure that he received it.
Well, he did. It showed me that he got my paperwork. He admitted in the last receipt that he received my
Okay,
paperwork.
and
So why would he send it? Well, not, why wouldn't I get it back? My email is legit. It's my phone right here.
okay,
Also a jurisdictional challenge,
let's,
right?
before we get to that, AJ said something you want to respond before we forget.
Yes, Your Honor, I do want to make a record. You know, this defendant has already availed himself to the jurisdiction of the courts of the state by admitting to having a driver's license. And also further add that the 10th Amendment has allotted and given police powers to the states, which then allows the state to create criminal laws under which this defendant must avail himself to. I further add that, again, as the court has acknowledged, that this defendant has at least once received the discovery to his emails, to his correct email. So any more allegations of not receiving discovery would be improper, given that we have it at least proven that he has it at least once. And there have been no additions or corrections since the discovery was done the first time.
Okay,
May I
Mr.
respond?
McCurry, I'm gonna wrap this up, you can respond and.
Yeah, just briefly if I may. Well, this young lady here to basically
Mr. Sessions,
respond, Mr. Sessions, to respond to her statements in Michigan. They're locking people up for not having a driver's license. I was compelled.
there are people
But I
getting locked up
reserve my
for
rights. This was the
murdering
law.
people as well.
Pardon?
People get locked up for murder as well.
Well, I understand that, but what I'm saying is the corpus delicti, they're going off written statements. You know the corpus delicti rule under the Michigan Supreme Court case, as well as the federal court case. Where's the body of a crime? They're saying ammunition, all this, that. Where's the guns at? Where's the victim at? Strangulation, where's all this? Where's the medical?
I wouldn't know because we haven't
And
had
then,
an exam.
okay, but no, jurisdiction, once it's challenged, it must be proven by the people. This is state and federal law, from the Michigan court.
Now this is where it gets interesting, because you can almost see your brain trying to figure him out in real time, like, is this guy clueless, or is he playing some long game to stretch things out? And honestly, it might be a weird mix of both. He is not screaming nonsense, like the usual sovereign citizen meltdown. You expect he is actually talking in full sentences, citing case law, throwing around legal phrases, and for a second, it almost sounds polished, but then you actually listen to what he is saying, and it completely falls apart, because none of those cases apply to what is happening here. And that little moment where he claims there is no victim or weapon, when they are not even at the preliminary stage. Yet that is not strategy, that is just misunderstanding how procedure works, and sometimes people mistake confidence for intelligence. He sounds smooth but substance-wise. It is empty calories, and the constant interruptions are not genius tactics either. Judges do not reward that, they punish it, and dragging things out rarely helps when the prosecutor already has evidence lined up. So at this point, it does start to feel less like a mastermind move, and more like someone who genuinely enjoys the sound of his own voice, while convincing himself he is winning a debate that is not even happening.
Oh, I'm demanding that they're already in default, but still again, I'm demanding jurisdiction be challenged, personal subject matter and territorial jurisdiction. Even when I was in prison, I had interactions with Kim Worthy, chief prosecuting officer for the state, and I reserved my rights in prior proceedings, as well as I was compelled to obtain a driver's license. And I reserve my rights. That's all the law mandates, that I reserve my rights, which I have done. And right now, this lady, Mrs. Prosecutor, I can't remember her name, and Mrs. Sisson, Esquire Sisson, and this gentleman here, they're in conspiracy and violating federal and state law. They're committing crimes, and I demand that their oath of office, their law, their license to practice law, amongst other things, be given to me, as well as their bond, as well as you, Judge, Your Honor. Also, like I say, jurisdiction has been challenged, and they have to prove it first based on the case law. which I have noted in this paperwork. They can't get around that. We can say, well, yeah, they're talking about reserving rights and all that. Okay, but still the law from the state Supreme Court, Court of Appeals, and federal jurisdictions clearly mandates that once jurisdiction is challenged, the person asserting jurisdiction has to prove it. And all they have is statements. Under the corpus delicti rule, out of court statements is not evidence, so these charges should be dismissed. Where is the body of the crime, Judge? You went to law school, you're a practitioner.
I don't know because I haven't heard testimony to know.
Well, that's not how it works with jurisdictional
That's
challenges.
how, you know, that way.
So,
Do you have any last?
Well, I would like,
statements, because I'm in the.
okay, I would like to challenge jurisdiction again, which I have done from the onset of this case, personal, subject matter and territorial jurisdiction. State and federal case law is clear, in which this court being inferior to the higher courts must adhere to their oath of office, their bond, and so on and so forth, their license to practice law and the Michigan rules of code of judicial conduct, and must compel the people to prove jurisdiction, which they're asserting. Where's the proof? You have to show this court. That's at any stage of the proceeding, the law allows that.
Okay. So on discovery, I saw paperwork confirming the email address that you provided to the court is now the record, that discovery was sent. I'm not sure if it's an email, please don't interrupt. If there's another email you would like to be sent to, I will ask the prosecutor to do so. 2, for requesting license numbers from everyone. My name is right here in front of you. You can go right on State
I
Bar.
ain't saying that.
RP numbers are available for you to look up as they are for any general public, okay? As far as venue, jurisdiction, and you mentioned this, you don't know whether I was appointed or elected, I was both.
This is the part that really gets under your skin because the court system is already slow by design, and then someone like this walks in and turns a simple matter into a full-blown performance over imaginary loopholes while real victims are stuck waiting their turn, and that frustration is valid because if you drive you need a license, it is not some hidden riddle buried in ancient text, it is basic law, yet he acts like he uncovered a secret code that only he understands, and the wildest part is the confidence they bring to it. They can be completely wrong and still argue like they are delivering a historic speech. Meanwhile, all they are doing is digging the hole deeper, and no matter how many times this strategy fails, it never seems to stop the cycle. And you are right, there is usually an echo chamber waiting outside the courtroom ready to applaud them and call it a victory, even when it clearly was not so when it comes to whether they believe it or are just gaming the system. The honest answer is probably both. Some genuinely buy into the ideology because it gives them a sense of control and identity, while others lean on it as a last-ditch shield against consequences. Either way, it almost never works, and the only guaranteed result is more time wasted, more patience tested, and sometimes more jail time stacked on top.